The last branch that we're going to be talking about is the judicial branch. And kind of like it sounds, like judge or jury, that's what it's all about. It's about the law. And it's really about to interpret and apply the law. And that is what this does. But it does it on a federal level. And because it does it on a federal level, it kind of sets the tone for the rest of the nation. So this power that the judicial branch holds is vested in the Supreme Court and the inferior federal laws, or federal courts. Sorry about that. So the Supreme Court was created by the Constitution as a court of last resort regarding federal law. That's why when we hear a case got to the federal law, it went from original court to a state court to the federal court all the way to Supreme Court. There's also a number of other courts that also do a lot of federal work when it comes as well, but the top and the highest one is the Supreme Court. So there is the 12 justices, a part of the Supreme Court, and they are selected by the presidents, and they have life terms to make sure that they also aren't biased. They can't be bought out, or they can't be influenced about certain decisions every couple of years to get reelected. It is a life term. So once you're in, you are in until your resignation or until your death. There are also two separate court systems in the U.S., the federal courts and the state courts. The federal courts, there's a separate appeals in there. And for the state court, it goes from the local court to the state appeals court to the state Supreme Court and so forth. So a lot of different ways, but really the judicial branch is to interpret and to apply the law that the legislative and executive branches put forward. So that is their job in the checks and balances and separation of powers. As I said before, the highest court in the nation, in the judicial branch, is the Supreme Court. So as I mentioned before, the justices are appointed by the President of the United States to a life term. And there's also the Chief Justice plus 8 Associate Justices. That makes 9. So that means that there are 9 judges. So there's not an even number, that there can be split decisions. That way, there's always going to be a decision on a case, regardless of if there's a pretty even difference. So most cases heard by the Supreme Court is from the appeals of the lower federal courts. So the courts that keep on going higher and higher. Decisions are made, but they're kind of not too set, or there's still some room for discussion or something like that. And the biggest part of the Supreme Court and the judicial branch's separation of power and checks and balances comes from judicial review. That's how they keep the legislative branch and the executive branch in check. It first came up in Marbury versus Madison all the way back in 1803, and it still is applied and very evident today. So the Supreme Court actually claimed that the power put forth by John Marshall, they declared that his acts were unconstitutional. They were fighting a constitutional law. So that is where the judicial review comes into play, and it's very powerful. So if they think that the president or they think that Congress is acting out of order and applying too much power, they can kind of put in judicial review to make sure that they don't do this anymore, and it's really, really effective. So next we're going to watch another crash course on this as well.
Hi, I'm Craig, and this is Crash Course Government and Politics, and today we're going to talk about the most important case the Supreme Court ever decided, ever. No Stan, not Youngstown Sheet and Tube Company versus Sawyer, although that is one of my favorites. Loves me some Sheet and Tube. And no, it's not Ex parte Quirin, although I do love me some inept Nazi spies and submarines. And no, it is not Miller v. California. Get your mind out of the gutter, Stan. We could play this game all day, but this episode is about judicial review, the most important power of the Supreme Court and where it came from. Don't look so disappointed. This is cool. When you think of the Supreme Court, the first thing you think about, other than those comfy robes, is the power to declare laws unconstitutional. The term for this awesome power, the main check that the court has on both the legislative and executive branches, is judicial review. Technically, judicial review is the power of the judiciary to examine and invalidate actions undertaken by the legislative and executive branches of both the federal and state governments. It's not the power to review lower court decisions. That's appellate jurisdiction. Most people think of judicial review as declaring laws unconstitutional, and that definition is okay. But legal purists will quibble with you since since judicial review applies to more than just laws. Appellate courts, both state and federal, engage in some form of judicial review, but we're concerned here with the federal courts, especially the U.S. Supreme Court. The court has the power to review the following. 1. Congressional laws, aka statutes. Since judicial review is a form of appellate activity, it involves upholding or affirming the validity of laws, or denying it, invalidating the law in question. You might think that the Supreme Court does this a lot, but it doesn't, and historically it almost never happened before the 20th century. If the court were always striking down congressional statutes, it would be hard for people to know which laws to follow, and you'll remember one of the main things that courts do is create expectations and predictability. For instance, you could predict that I would eventually be punching this eagle. Another reason why they don't invalidate laws often is that if the court frequently overruled Congress, the court would seem too political and people would stop trusting its judgment. If the court has any power at all, it largely stems from its prestige and reputation for being impartial and above politics. No one has any problems with the Supreme Court decisions at all. 2. The court can also overturn state actions, which include the laws passed by state legislatures and the activities of state executive bureaus, usually the police. The power to review and overturn states comes from the Supremacy Clause in the Constitution. Most of the time that the Supreme Court extends civil rights, it comes out of a state action. A good example is Brown versus Board of Education, where the court struck down the idea of separate accommodations being equal in the context of state public schools. 3. The court can review the actions of federal bureaucratic agencies, although it will usually defer to the bureaucrat's expertise if the action is consistent with the intent of the legislature, which the court usually finds it is. The court almost never strikes down congressional delegation of power to the executive, although you might think that it should. The fourth area where the court exercises judicial review is over presidential actions. The court tends to defer to the president, especially in the area of national security. The classic example of the court overturning executive action happened in U.S. versus Nixon, where the justices denied the president's claim of executive privilege and forced him to turn over his recordings relating to the Watergate scandal. More recently, the court placed limits on the president's authority to deny habeas corpus to suspected terrorists in Rasool versus Bush. So, the Supremacy Clause gives the court the authority to rule on state laws, but where exactly in the Constitution does the power of judicial review come from? Trick question! It's not there. Go ahead, look, I'll wait. See? Not there. Wow, you went through that whole thing really quickly. Fast reader. The crazy thing is that the power of judicial review comes from the court itself. How? Let's go to the thought bubble. The Supreme Court granted itself the power of judicial review in the case of Marbury versus Madison. You really should read the decision because it's a brilliant piece of politics. The upshot of the case was that Chief Justice John Marshall ruled that the court had the power to review, uphold, and strike down executive actions pursuant to the Judiciary Act of 1789, and in doing this, to strike down part of that federal law. How he got there was pretty cool. So Marbury was an official that President John Adams, at the very end of his term, appointed to the position of Justice of the Peace. When Marbury went to get his official commission certifying that he could start his job, James Madison, who was Secretary of State, refused to give it to him. So Marbury did what any self-respecting petitioner would do. He went to the Supreme Court for a writ of mandamus that would force Madison to give Marbury his job. This is what he was supposed to do, according to the Judiciary Act of 1789. What Marshall did was brilliant. He ruled that, yes, Marbury had a right to the commission, but that the Supreme Court could not grant his writ because the law directing them to do so was unconstitutional. This is brilliant for two reasons. First, by the time the case came before the court, Thomas Jefferson was president. Those of you who remember Crash Course U.S. history will recall that that less handsome man told you that Jefferson was a Democratic Republican, while Adams, Marbury, and even Marshall were all Federalists. By ruling against his own party, Marshall made a decision that was favorable to Jefferson, and thus likely to be supported. The second move is even cooler. Marshall's ruling took the power to grant writs of mandamus away from the court, making it look weaker, while at the same time giving the court the power to declare the law that had granted it the mandamus power in the first place unconstitutional. So by weakening the court in this instance, like Daredevil going blind as a kid, Marshall made it much stronger for the future, like Daredevil getting stronger in the future. Thanks, Thought Bubble. So that's where judicial review comes from, but that still leaves many questions. A big question is, why has this ruling stuck around and hasn't been overturned by other laws or later court decisions? Another question is judicial review a violation of separation of powers? Some say that it's judges making laws, and thus an anti-democratic usurpation of the legislature's power. Let's talk about this ruling's longevity first. Remember when I said last time that the Supreme Court rulings are binding in lower courts? You don't remember, do you? You were sleeping. Wake up! Well, in general, Supreme Court precedents are binding on future Supreme Courts too because of the principle of stare decisis, which is Latin for let the decision stand. This doesn't mean that future Supreme Courts can never overturn the decisions of prior courts, it's just that they try very hard to not do it. This idea of precedent is one way that judges can be said to make laws. Appellate decisions are like common law in that they're binding on future courts and constrain their decisions and because they don't have to be grounded in a specific statute. Other courts have to follow the higher court's interpretation of the law, and this interpretation has the effect of redefining the law without actually rewriting rewriting the statute. On the other hand, appellate decisions are technically not common law in that they are only binding on courts, not executive agencies or legislatures. They are, however, signals to courts and legislatures about how courts will rule in the future. Maybe an example will help. If you watch cop shows or you get arrested a lot, you probably know something about Miranda versus Arizona, which gave us the Miranda warning. You have the right to remain silent and all that stuff. Hopefully you've never heard that in person though, but hey, we're not here to judge. That's what the courts are for. Okay. In that case, the Supreme Court threw out Miranda's conviction because he hadn't been told that he had the right to remain silent. Without knowing that he didn't have to talk, he made a confession that got him convicted. The court didn't rewrite Arizona's law, but it sent a signal to Arizona's law enforcement agencies and those in all the other states that in the future, courts would throw out the convictions of defendants who hadn't been informed of their rights. As a result, police procedures changed in every state, and now the police are supposed to read the Miranda rights to anyone they arrest. So those are the very basics of judicial review. We've probably raised as many questions as we've answered, but that's why we're making a bunch of these videos, so we can teach it all. All of it! Anyway, the big concern for many is that cases like Marbury versus Madison, which give courts the power to strike down pieces of legislation, overturn the judgment of the elected representatives that made the laws and violate the idea of separation of powers. Well, that is a thorny issue, but it's one we don't have time to de-thorn today. For now, understand that judicial review is how the courts work in practice, and not necessarily a defined power granted by the Constitution. Just remember, the executive and legislative branches also operate with a lot of implied powers that aren't explicitly granted to them in the Constitution. That's because the governance of the United States has evolved and changed over time to hopefully suit the needs of the country as they change over time. Thanks for watching. Crash Course Government and Politics is produced in association with PBS Digital Studios. Support for Crash Course U.S. Government comes from Vocal. Vocal supports nonprofits that use technology and media to advance social equity. Learn more about their mission and initiatives at vocal.org. Crash Course was made with the help of these nice people who have the right to remain silent. Thanks for watching. You have the right to stop watching if you want.
So, hope that video gave you a better idea of what the judicial branch and their powers are. So, for tomorrow, we're going to be looking at case studies, so specific cases in the past where not only judicial review is in play, but also some very important decisions are in play that I think you guys are going to enjoy. So tomorrow, come prepared to study some past cases that the Supreme Court viewed as well, to put your opinion on it and to see the decisions made by the Supreme Court and the powerful judicial branch.